Hello, and welcome to Kirkpatrick Price's Road to HIPAA Compliance Breach Notification presentation. Kirkpatrick Price is a licensed CPA firm specializing in information security and regulatory compliance audits, providing assurance services to over 400 clients in more than 46 states, Canada, Asia, and Europe. The firm has over 10 years of experience in compliance frameworks such as HIPAA and HITECH, ISO, and NIST. Some of the services that Kirkpatrick Price provides include regulatory compliance offerings, including consulting with policies and procedures, risk assessments, and internal audit plan development. We also provide readiness audits with respect to regulatory compliance frameworks. Kirkpatrick Price also provides information security auditing services, including HIPAA, SOC 2, SSA 16, PCI, FISMA, and ISO. In order to stay connected with what's going on with Kirkpatrick Price, you can subscribe to our blog on our website. Also on our website, you can check out our recorded webinars, such as the one we're going to present today, and you can also connect with us on LinkedIn. My name is Mark Heinley, and I'm a regulatory compliance specialist with Kirkpatrick Price. I've been a member of the Florida Bar with 9 years of experience in healthcare law, regulatory affairs, and internal compliance in both the public and the private sectors. I have experience serving in the General Counsel's Office for a state healthcare oversight agency, regulatory affairs for a Medicare, Medicaid, HMO, and also experience with complex healthcare litigation. I'm also SAN certified in the law of data security and investigations. Before we begin, I want to provide a disclaimer that this presentation is provided by Kirkpatrick Price for educational and informational purposes only, and it does not constitute legal advice. No attorney-client relationship is established by viewing this presentation, and should you need legal advice, we request that you please consult with your own attorney. Today's presentation is an additional step on our road to HIPAA compliance, and it's regarding breach notification. Today we're going to ask and answer 6 questions. What is a breach? Did I have a breach? Who do I tell about a breach? What do I tell them? How long do I have to report a breach? And what should I do to reduce risk? We're going to ask and answer these questions with a mid-level analysis. In other words, we're going to provide some detail, but it's not exhaustive. Our goal is to provide you the information you need to evaluate where you are with respect to the breach notification requirements and make any changes that are necessary. And the benefit from going through this kind of analysis and then looking at your breach notification policies and procedures is compliance with federal law, which reduces the risk of fines, and also protection of patient health information. So let's get started. The first question we're going to ask and answer is, what is a breach? Federal law defines a breach as acquisition, access, use, or disclosure of unsecured protected health information in a manner not permitted by rule, which compromises the security or privacy of the protected health information. So as we go through this definition, I want to identify 4 key elements to a breach that are important in both understanding a breach and then important in analyzing whether a breach has occurred. So the first of those 4 elements is whether there's been an acquisition, access, use, or disclosure. And we'll talk a little bit more in detail about these key elements in a little bit. The next is a breach has to involve protected health information. A breach also has to be disclosure not permitted by rule. As we'll note, there are many permitted disclosures allowed by the privacy rule. So a breach is a disclosure which violates the privacy rule. And then finally, a breach has to involve the compromised security or privacy of protected health information. And there's a specific analysis for analyzing whether PHI has been compromised in terms of security or privacy. So once we understand a little bit about what a breach is, we're going to analyze whether or not we have a breach. So just because there is an incident that involves health information or what could be health information at a covered entity doesn't necessarily mean there is a breach. You could have just an incident you could have a violation of the breach, the privacy rule that doesn't constitute a reportable breach, or you could have a breach that requires reporting. So we're gonna look at those three different potential outcomes by asking the question, whether or not we have a breach. The first part of the answer to that question is to know that there is a presumption by law that is rebuttable, but it is a presumption that any acquisition, access, use, or disclosure of protected health information in a manner not permitted by rule, which compromises the security and privacy of that protected health information, is presumed to be a breach. So as you draft your policies and procedures, as you go through training, and as you conduct analysis of whether or not you have an incident, a violation, or an actual breach, it's important to know that the perspective that you need to come at it with is, if there is an actual acquisition, use, access, or disclosure, and that acquisition, access, or disclosure doesn't fit within the privacy rule, or and there's a compromise to the security or privacy of that information, the Department of Health and Human Services presumes that to be a breach. Now, the way that you rebut that breach is when the covered entity conducts a risk assessment and demonstrates that there is a low probability that the PHI has been compromised. So as we go through the analysis of the key elements and the statutory exceptions and the risk assessment, we need to have in mind, in the back of our minds, that the law presumes an impermissible use or access or disclosure of PHI that compromises security to be a breach. So there is that presumption in place. So let's go through an analysis of the key elements before we talk about the statutory exceptions and the risk assessment step. So the key elements are the four that I mentioned earlier: the access, acquisition, use, or disclosure, PHI, not permitted by rule, and then compromised privacy or security of the PHI. So the first part is to determine whether there's been an acquisition, access, use, or disclosure, because if any of these key elements aren't met, then you merely have an incident or possibly a violation of the privacy rule, but you don't have a reportable breach. So it's important to break down what happened and evaluate these key elements to see if you have an incident, a violation, or a breach. So first is the acquisition, access, use, or disclosure. Those four means of someone obtaining or disclosing PHI indicate that a covered entity in possession of PHI can be both an active or a passive participant, and a breach still occurs. So it's important to understand that a breach can occur when a third party hacks into a computer network and obtains PHI, or it could involve a situation where a covered entity leaves paper records that include PHI outside of a public dumpster or recycling bin, and individuals can access those records. Both of those would meet the definition of an acquisition or a disclosure. So to meet this portion of acquisition, access, use, or disclosure, it has to be usable data. There's a couple of things that could occur where an incident could occur, but not a violation or breach. One of those is when there's usable data that isn't actually accessed. So, for example, an unencrypted laptop that's left at a restaurant, but forensic review and maybe if the restaurant has security cameras covering the place where the laptop was left, indicate that the laptop was never opened up and logged into. So that laptop could have had thousands and thousands of records of PHI, and those records were accessible and not encrypted, and so there would be an opportunity for there to be access or use. But if no one actually picks that laptop up and signs in and views it, then you don't necessarily have a violation or a breach. You could have a similar situation where there's a laptop left at a public place, and someone does open up that laptop and tries to log in or actually logs in, but if the PHI is either encrypted or de-identified and they're not able to acquire or to access or to use that information, then you don't actually have, you have an incident, but you don't necessarily have something that meets one of the key elements of the breach notification rule. So in analyzing whether you have acquisition, access, use, or disclosure, you need to know whether or not there's usable data, and whether that if there was usable data, whether that data was actually accessed or used. The second key element is whether or not the information that was accessed or used or disclosed was actually protected health information. So we're talking about the standard PHI elements: name, social security, date of birth, and connection, and possibly in connection with other healthcare test results. We are not talking about proprietary identifiers that a covered entity uses, or certain healthcare indicators that aren't connected to personal information, like heart rate without connection to a name or social security number. So you could have accessible data that's actually viewed by a person not connected to or not authorized by the covered entity, but if it's not actually PHI, then you don't have a breach. The third key element is that this access that occurs for usable data that's actually PHI has to be one that's not permitted by rule. So the privacy rule contains all kinds of permissions to disclose PHI, including for the provision of services, for operations, for billing, for research, for certain healthcare emergencies. So even if you have an access of actual PHI, you need to analyze whether or not there's a part of the privacy rule that permits such access or disclosure before determining whether or not you have a breach. The fourth and final key element is whether or not the impermissible acquisition, access, use, or disclosure of PHI compromises the security of or privacy of the information. And the way that you can evaluate that is by conducting a risk assessment that we'll talk about in just a minute. Before we get there, though, I want to identify there are three specific statutory exceptions where there's PHI that is accessed or disclosed or used or acquired by someone who isn't a part of the covered entity, and it's PHI, and it's not permitted by rule, and it would otherwise compromise the security and privacy of that information. But the law says this doesn't count as a breach. The first of those three is when there's an unintentional acquisition of PHI made in good faith by a person acting under the authority of a covered entity. So if a provider accidentally was told to grab a set of medical records by someone else at the covered entity, believing it was for a patient of that provider's, when instead the provider grabs records of another patient that the provider is not seeing or not providing services to, then that would be access of PHI that's not necessarily permitted by rule, but you would have an exception. The second is when there's an inadvertent disclosure of PHI from one person at a covered entity to another person at the same covered entity. So if a provider accidentally shared test results in the name of a patient with, in the hearing of another provider who's not seeing that patient, that would be the disclosure of PHI in a manner that's not permitted by rule that could compromise the security or privacy of the information. But again, the law says if it's an inadvertent disclosure, it's one person at the covered entity and it's to another person at the same covered entity, then you don't necessarily have a breach. The third and final exception is when the covered entity has a good faith belief that an unauthorized person isn't likely to retain the protected health information. So, for example, if a provider or an administrator or another patient overhears some healthcare information, but they don't have enough, they didn't hear it well enough, or they didn't hear it for long enough so that they would be able to retain it and then use it in a way that significantly compromise that information, then you have a statutory exception. So you need to go through the four key elements and determine that all of those are met before you have a potential breach. But even if you go through those four key elements and all of those four are met, you could still have a statutory exception in which case you don't have a breach. And even if all four key elements are met, and you don't have a statutory exception that applies, you don't necessarily have a breach that's reportable to any of the parties that we'll discuss later. You'd have a violation of the rule, but the law requires reporting only when a certain standard is met. So the law requires, the breach notification rule requires entities who have an incident to investigate it and conduct a risk assessment with 4 elements and determine if at the conclusion of that risk assessment, whether or not there's a low probability that the PHI has been compromised. If there is low probability that the PHI has been compromised, then the covered entity has to document their findings, but they're not required to report that incident. If at the end of the risk assessment, the covered entity determines that there is not a low probability that the PHI has been compromised, then the covered entity is required to report. So let's talk about the 4 elements of the risk assessment. The first is the covered entity needs to analyze and understand the nature and the extent of PHI involved. So if you had, let's say, names only, and those were the items disclosed, you might have a certain risk of compromise. If you had names plus dates of birth and social security numbers and credit card information and test results, you have a much higher probability that your PHI is going to be compromised. The second element of the risk assessment is determining who is the unauthorized recipient or who are the unauthorized recipients of the PHI. So if the unauthorized recipient is another healthcare provider within the covered entity, then you have a lower probability of PHI being compromised. If the unauthorized recipient is someone who is not a part of the covered entity, if it's another patient, if it's a member of the public, you have a much higher probability of the PHI being compromised. The third element is whether or not the PHI was actually acquired or viewed. So if you have someone walking by a computer screen and there's PHI on the computer screen and they walk by very quickly, then you might have a lower risk that the PHI is compromised. If you have a printout of a name and a date of birth and some test results that's given to the wrong patient, then you have a much higher probability of compromise based on the nature of that viewing and that acquiring of the PHI in the paper format. The fourth risk assessment factor is the extent to which the covered entity has mitigated the risk. So if the covered entity sends out an email or follows up with on an inadvertent disclosure and or unsends an email or doesn't discover the information or the incident for several days and continues to exacerbate the disclosure, then you have different levels of risk of compromise. So for example, let's go through an example and see whether or not we think there's a lower or higher probability of compromise based on the 4 elements of the risk assessment. Let's say that PHI, including a name and a test result, was mailed in paper format to the wrong doctor. And that doctor notifies the covered entity that she has destroyed, immediately opened it up, realized she wasn't intended to be the recipient of the PHI, and has destroyed the document. In that case, I think that there is a lower probability of the PHI being compromised. It was the limited amount of PHI. The unauthorized recipient was another healthcare provider. While the provider had a chance to probably review that information, the risk was mitigated by the provider immediately realizing the mistake and shredding the document so that there's no possible further disclosure. From a federal government perspective, this risk assessment step is an area of concern. The Office for Civil Rights at DHHS has noted a couple of different areas of concern for the risk assessment: a lack of of policies at all or policies that are sufficient, a lack of proper execution of the risk assessment step. So even those entities, those covered entities that have a risk assessment policy are not always understanding what they're supposed to be doing and properly going through those 4 elements. And then finally, a lack of documentation of the risk assessment. So even in the event that a covered entity has proper policies and procedures, properly executes a risk assessment, they're not always documenting it in a manner sufficient for the Office for Civil Rights. So with that in mind, it's important to consider where your breach notification policy is with respect to your standards and your documentation regarding investigations of the key elements, understanding the statutory exceptions, and going through the risk assessment process. Those policies and procedures and your training and your controls should be designed knowing that the law starts with the presumption that an impermissible access, use, disclosure, or acquisition of PHI is a breach. And so you could go one of two ways. You could create a policy that just says, we report everything, and then you wouldn't actually have to go through the risk assessment process, but you would have to go through all of the steps that we talk about later, which could be significantly administratively burdensome. But it would be one of those approaches where you might err on the side of safety and create a more administratively burdensome process. Or to reduce the administrative burdens of reporting the right information to the right kinds of people within the right time frame every single time you have an incident, you could design a policy that says that you're going to go through the risk assessment process, you're going to do an investigation of the key elements, you're going to identify whether or not a statutory exception applies, and you're going to document, and then you will determine whether or not you just had an incident where you think something happened and you investigate, but you find that there's been no violation of the rule, or you find that you had a violation, that is, you didn't comply with the privacy rule, but you completed a satisfactory risk assessment and you determined that there was a low risk of compromise, and so you just have to document your findings. Or you would come to the conclusion potentially that you have a breach, in which case we'll go through the steps of what happens when you actually have a breach. So after you understand what a breach is, you need to ask yourself if you had a breach. Knowing the presumption, knowing the key elements and analyzing whether all of those have been met, knowing the statutory exceptions for even when the key elements are met, but it still doesn't constitute a violation of the rule, and then when the key elements are met and no statutory exception applies, and you can complete the risk assessment step to determine whether or not you actually have to report. So once you've decided that you have a breach, or once you've decided that your policy is going to be that you report everything, here are some of the additional issues that you need to address. So the first is you need to ask, who do I need to tell when I have a breach? And covered entities have 3 parties potentially that they have to tell. There will always be 2 parties that you have to tell. If you actually have a breach, you'll always have to notify affected patients. Secondly, when you have a breach, you always have to notify the Department of Health and Human Services. We'll talk about that notification, how it occurs and when it occurs, when it needs to occur a little bit later on. But when you have a breach, you always have to notify the affected patients and the Department of Health and Human Services. The third potential party that you need to notify is the media, and that's in the event that more than 500 individuals have been affected. So this is why it's so important to understand what a breach is and to go through a sufficient analysis of whether you had a breach, is because it's not just determining whether or not you had a breach, it's determining the nature and the scope of that breach, because the nature and scope of that breach has significant consequences in who you tell and how you tell them and how quickly you tell them. So after having determined whether or not you need to include the media and in your reporting, the next step is asking and answering what do you need to tell them. So in order to properly comply with the breach notification rules requirements on breach notice, the actual notice, you think about this like the questions a basic journalist would ask when writing an article, and you pretty much have the items you need for a breach notification, you know, who, what, why, when, and how. So the first thing you need to tell people is what happened. Describe the nature of the breach. Was it a hack? Was it the loss of removable media? Was it explanations of benefits sent to the wrong people? Was it a fax sent to the wrong doctor? Was it the fax sent to the wrong billing entity? Describing exactly, with enough detail, the nature of the breach. The second piece of information required in a breach notification is describing what kind of PHI was disclosed in the breach. So are we talking about just names? Are we talking about social security numbers, dates of birth, test results? The breach notification rule requires that this information be described with enough specificity that the affected patients can understand exactly what parts of their PHI were disclosed. The third piece of information that's required for a breach notification is to include the steps that a patient should take to mitigate harm. So the most common example is to let patients know that they should notify credit reporting agencies that there's potential for identity theft. But there may be additional steps that a patient should take depending on the nature of the breach and the kind of PHI that was involved in the breach. The fourth item required in breach notification is to tell particularly affected patients what kind of steps the covered entity is taking in terms of its investigation and mitigation of future harm. So what is the covered entity doing to evaluate the breach, and what is the covered entity doing to mitigate the risk of harm from that breach and also for future breaches? Are there steps they're taking in terms of training or encryption or other steps that would reduce the potential for this same kind of breach to happen again in the future? And the final piece of information, and one that's perhaps the simplest, but is also somewhat frequently forgotten, is contact information. Covered entities need to let affected patients know how they can contact the covered entity to ask them questions about the breach. And that should include things like a toll-free number, an email address, a website if available, and a physical address. And one of the things that covered entities should note if they're going to create a website for the breach, or if they're going to include breach information on the website, is the Department of Health and Human Services likes to see websites updated on a somewhat regular basis on the status of the covered entity's investigation and mitigation. So it's a requirement to include all 5 of these types of information in a breach notification. And then there's an additional requirement that is another area of emphasis by the federal government that impacts all 5 of these types of information. And that is, the breach notification to affected patients has to be in plain language. The government doesn't want to see copying and pasting of technical standards or NIST or some other very kind of detailed healthcare medical descriptions that the average patient wouldn't understand. So in addition to having all of these 5 types of information in a breach notification, it is a requirement to have all those 5 types of information in a manner that is understandable by the patient. So if you have a breach, you need to tell affected patients, Department of Health and Human Services, and potentially the media. What you need to tell them is what happened, the types of PHI that were accessed or disclosed, the steps the patient should take to mitigate future harm, the covered entity's investigation and mitigation steps, and then also contact information. The next question to ask and answer is, how long do I have to report a breach now that I know that I have one and now that I know what I need to tell people? So for affected patients, no matter how many patients are affected, covered entities have to notify them within 60 days of discovery of the breach. If there are 500 or more patients impacted by the breach and therefore the covered entity has to notify the media of the breach, the covered entity also has to notify the media within 60 days of discovery. So the 60-day rule is a pretty safe standard for any of the reporting, with one potential exception. for every single breach, as we said, a covered entity has to notify the Department of Health and Human Services. But there is some choice, there is one choice that a covered entity has to make or can make with respect to how soon to report a breach. If a breach impacts 500 or less individuals, the covered entity can either notify the Department of Health and Human Services immediately or within 60 days of the end of the calendar year in which the breach occurred. So and that could be all of the breaches. So for example, all of the breaches that occurred in 2015 for a covered entity that impacted less than 500 or less people could be disclosed to the Department of Health and Human Services on or about March 1st of 2016. Or, as I said, a covered entity could notify the Department of Health and Human Services for all breaches on a rolling basis. Every time a breach occurs, they could notify, regardless of how many people are impacted by the breach. A covered entity would still be compliant with the rule if they notified the Department of Health at any point. However, if a breach impacts 500 or more people, then a covered entity is required to notify everybody within 60 days. That includes the affected patients, the media, and the Department of Health and Human Services. Now, when there's a breach and potentially involving some technical components, and when a covered entity is investigating how many people are impacted by the breach to determine what kind of regulatory requirements apply, there's certainly a need to be thorough. But the federal government has emphasized that it's important not to wait any longer than necessary, even within the 60 days, to properly disclose a breach. So there's a tension. The rule requires notification within 60 days, and entities typically use that entire time period. But there's also a sense in which the government, although it can't necessarily do anything about it, prefers to see covered entities report breaches, especially to impacted patients, as soon as possible. So now that we know how long we have to report a breach, let's talk about this and how to determine whether we have one and what we have to tell people when there is a breach. Let's determine and talk about what we can do to reduce risks so that there isn't a breach in the first place. So what can you do to reduce risk? The first thing you can do is to establish policies and procedures. At the most basic level, identifying whether or not you actually have a breach notification policy. Second level is reviewing that breach notification policy to determine, is it up to date? Do the right people know about it? Does it include all of the key elements that we talked about at the beginning, including the risk assessment? Has it been reviewed? Has it been published? All of those elements. And then making sure that the procedures for your entity are consistent with your policies. The second thing you can do to reduce risk is to have the proper training. And that includes more than just giving people a piece of paper or a link to a policy and a procedure on an intranet page. It involves a thorough instruction of letting people know what constitutes a breach and what they have to do if they're concerned that they have one, especially letting staff and everyone know who the right people are to notify if they're concerned that there is a breach. A third way of reducing risk is testing your policies and procedures and your training. Conducting a mock breach assessment to evaluate whether or not there's any gaps in your policies and procedures and whether or not there's any gaps in your training, whether or not everyone knows what to do in the event that there is a potential breach, and then whether or not the investigation follows all the steps it needs to follow. So one of the ways that you can reduce risk for a breach is to test your current practices for addressing the breaches, potential breaches. A fourth way to reduce risk is to implement operational controls. So these aren't necessarily breach-specific activities. They're controls that you implement so that you can reduce the number of times you need to go through this exercise and the potential harm to patients and the potential compliance sanctions. The first is encryption. even if encryption is a significant administrative and financial and technical burden on an entity, it's almost always the case that encryption is less of a burden than notifying thousands or millions of patients about a potential breach. It's also a way to reduce the risk of a breach occurring at all. Another operational control to implement that's relatively simple is on-site destruction of media and documentation. One of the biggest breaches that occurred in recent years was when an entity that was using proper document destruction protocols had a document destruction company come out and take the documentation off-site, and the truck lost records literally on the road and dumped hundreds of thousands of records on the road, and hundreds of thousands of patients were impacted. Almost 500,000 patients were impacted. So on-site destruction can ensure not just that the documents are destroyed, but they're destroyed in the most effective manner possible. A third operational control is to ensure network security, that your network has all of the information security industry standard designs and gatekeepers in place, and in terms of a technical aspect, and then from an administrative aspect, that access to PHI is limited to the people that need it, and only the people that need it are only accessing the PHI to which they need to do their job. And then the fourth thing is to have network access audits. So if you have standards in place to limit access to PHI, to evaluate whether or not that access is what's actually occurring, or whether or not you have some potential incidents. Because one threat to a healthcare entity is either a disgruntled employee or an employee with nefarious intentions who's trying to access or is accessing PHI from within. So a network access audit should be sufficient to review who's accessing PHI, how frequently, and whether or not that's consistent with what their job description entitles them to access. And then the fifth and final means for at least for this discussion to reduce risk is to engage third parties to conduct audits of your organization to determine whether or not you have sufficient controls in place, whether you have gaps, and to give you the kind of analysis you need to remediate any risk. And those audits can include things like HIPAA and high tech, as well as SSC 16 and SOC 2, penetration testing, any kind of relevant third-party audit, depending on the nature of the activities that you provide, the size of your organization, the technical sophistication of your organization, making sure that you have an objective eye reviewing all of the things that you're undergoing or should be undergoing. So as we've gone through all of these points, it's essentially been a presentation to covered entities about breach notification, and I want to make sure that business associates don't feel like Rodney Dangerfield and get left out and feel like they have no respect. On the positive side, though, that the reason that we've talked exclusively to this point about what covered entities should do is because business associates really only have two things to keep in mind with respect to breach notification. Now, they need to have all the controls in place to limit risk like a covered entity does, but in terms of their actions once they think a breach occurs, is just to report to the covered entity and to do so within 60 days of the discovery. So the kind of analysis that we talked about, the policies and procedures regarding what level of analysis the BA is going to go through before notifying the covered entity, whether or not that kind of notification is governed by the business associate agreement, and the BA is simply required or is stringently required to just report everything so that the covered entity can conduct the analysis and make the determination about whether it's actually a breach or it's a violation or it's just an incident, or whether the covered entity requires the BA to do some of or all of that analysis on their own. And so reporting to patients, reporting to the media, reporting to Department of Health and Human Services through the web portal, all of that is a requirement of the covered entity. But the BA has to just remember to maintain its controls and then report to covered entities and do so in a timely fashion. That concludes our presentation on breach notification. Just to give you an overview of Kirkpatrick Price's roadmap to HIPAA compliance, starting with what has occurred already this year. In January 2016, we talked about risk analysis and risk management. This was a breach notification for March 2016. Coming up, we have policies and procedures. Then we're also going to be talking about the privacy rule and security rule, managing business associate compliance, training, incident response, cybersecurity, and then finally we'll conclude in November with trends and enforcement activity. We appreciate your attendance on today's webinar and remind you to look forward to April when we'll be talking about developing policies and procedures for HIPAA compliance. If you have any questions, you can contact me. Again, my name is Mark Heinley, and you can contact me at m.heinley@kirkpatrickprice.com. Thank you very much again for your presentation, for your attendance at our presentation, and have a nice day.